Good afternoon.
Good
How's
afternoon.
yes, how's everyone?
Great.
Good afternoon.
Good afternoon. Wonderful. It's so glad to hear everybody is great.
Yeah. So great to be great.
Denise,
Yes.
I soon call you. Work is be taking me right down, girl.
That's all right, man.
Work is putting me in a chokehold and hold me there.
Yeah.
That's the
All us,
beauty.
you gotta control that.
But that's the beauty of working. It keeps your mind stimulated.
Yeah. Along with this class.
But you'll find time. I heard them talking on the radio this week. They were talking about Alzheimer's, dementia, and they were saying that once you retire, they're advising people to continue not working like how we work 9 to 5, but do things to stimulate the brain, because they're finding
Sure.
out that it starts to die very quickly if it's not active.
Yeah. I mean, a little disclosure. I stayed away from any sort of, structured continued learning like this since I left university many years ago. And
Uh-huh.
to pull myself together to make sure this is a successful venture here, I had to make more changes and just focusing on, you know, reading and retaining. I feel a lot more clarity, with the changes I made, as well as having to focus on this and kind of open up my mind.
Yeah. So
So,
sometimes it may not pertain to your work, but it is good to go and learn new things just to
yeah,
keep the brain active.
yeah, keep those synapses firing.
Yeah. Because let's just say if you did it, um, just did a course, it was a difficult course. Let's just say, but you fail. The point is not whether you pass or fail at that stage. It's whether or not you were able to keep up, do the reading. It stimulates the mind. You probably got as close as you could get. But the point is that in that period of time, if you had done nothing, which would have been a 3 or 4 month space time, your brain would have deteriorated by a certain percentage. So it's
Yeah,
always good.
yeah,
And that's
yeah.
why I like to challenge you all and give you all nice reading, nice cases to read, keep you active.
Well, thanks so much, Erin.
Just letting
Uh-huh.
there's a method to this.
Yeah.
I want to keep you all very active. Now I'm trying
Uh,
to confirm with the office if the midterm is actually in class, because another class that I have, they changed it to actually being in class, because the last time we had the class, the students complained that doing it online, theirs was online. They said it was difficult and they preferred that they have it in class so they could have more time and they could sit down and do it. So hopefully he'll confirm that before we finish today. Or I'll just send
So
you the
that wouldn't be a class preference? Yeah, because I thought it was a take home.
I thought it was a take home, Sasha.
Yeah, well, I'm trying to find out right now. Because I thought so too. But anyhow.
so it would be different. It would be a different assignment then, right?
Yeah, it'll be different. Okay, I'm just texting in now. Okay, all right, let's go. It's a short class today, except for our presentation, because you have to get ready for your midterm. It's chapters 1 to chapter 5. You want a little bit of multiple choice, or you just want me to do scenarios?
All multiple choice.
All?
Multiple choice.
Multiple choice.
I don't think that's an option, my friend.
No, not for home. No, not for take home. No multiple choice. Scenario. And
Scenarios are awful.
I want you to use your brain. It won't be that difficult. Come on. Chapters 1 to 5.
It's actually we use our brain from Monday to Friday, 9 a.m. to about 7:30 p.m. And only lunch break too. And then when you
That's
sleep and you remember something you didn't do.
you'd be like one of the staff members. He say, all of his previous jobs, he could go home and hang out. He said he'd go home now and he'd be tossing and turning. Did I call this one? Did I not call this one? He said, man, I can't take this job. I can't do this. It's just called stress. Don't
Yeah.
worry. It'll be okay. All right. So everybody have their cases ready? I think we
Yes.
have 4. Okay. So let's quickly go over the chapter. The chapter is very short because it's only about corporate record keeping. And it just speaks about how important it is to keep your corporate records. And the reasons why you keep it. Now, be mindful is not in here, but as a part of this corporate record keeping, you should have policies and procedures in place to ensure that you are keeping your documents within the regulatory framework. That's one of the key things that you have to be mindful of. You can keep the documents within the statutory framework, but you must have an overarching policy that speaks about record retention and when records can be destroyed.
I wondered why that wasn't in there. Yeah.
Seriously?
Me?
Yes.
Yeah, I wondered why there was no reference to record destruction. Yeah, because that's a big thing. Because I mean, there's penalties for not destroying records after the allotted time.
Mm-hmm. Yeah. I can add it in. I normally just mention it, but
That's
I can add.
fine. Yeah.
I'll add it in at the end about record retention and record destruction. Because apparently a lot of companies still store documentation past the statutory period.
Right.
Right. And if you have a request for information that you should have destroyed, but you still have it, then you're going to actually have to produce it.
Yeah. Just speaking about that for a moment, it was not even suggested. It was a part of another company's policy that in addition to destroying the physical documents that after, the retention period, that you are also supposed to delete or whatever, any electronic documents you may have pertaining to that company or relationship. And I didn't agree to that. I think that, if you have something you drafted in Word, that's a document that belongs to the actual company, being the corporate or financial service provider.
Agreed.
Right?
Well, I
Yeah.
agree. So if we look, let's say we take let's take just an individual and their passport, address verification, their references that they send. They're no longer a client. They don't do any business. Haven't heard from them in the last 5 to 6 years. So you decide, okay, so they're getting ready for destruction next year because some companies use a 7-year policy. So let's just say the 7 years is up. To me, the only thing you actually would keep is just a list of names, because sometimes they do come back after 20 years or so. And they'll say, Mary Sue, I was a client of yours and I want to do some business. And then you could just have a list of names. You could say, oh yeah, they were here, but there are no documents because they're in the folder that said was information destroyed. That's it.
Right.
Now, when it comes to a company, let's say the company was liquidated. The only thing you would keep would probably be the certificate of incorporation, maybe the memo notes, and then the final liquidators report, and all the rest of that is gone.
And why are you keeping those?
It has, if it hasn't passed the statutory period.
Oh, I see. I see. Okay.
If it's passed, it's gone.
Yeah.
Yeah.
Well, you said that some companies implement a 7-year retention period after the business relationship is closed. But don't you basically have to, because the beneficial ownership registry, whatever act states that documents are to be retained for 7 years. So, I mean, that's
Yeah. It said some do it 7 years. Some companies actually do it for 10.
oh, I see, but not under
Yeah.
that. I mean, you can't do it
No,
under that,
not a-
because I know some of the other acts say 5 years, but after the beneficial owner registry act came out, it was extended to 7.
Mm-hmm. Yeah, but some people keep it for 10. They're
Uh,
free to do it at 7. You know, some people just mindset, oh, someone can come. And I keep saying, if you keep it over the statutory period, that's why
That's
you
correct.
run around like chickens trying to find it when you shouldn't even have it. Because when you look
Yeah.
at and you look at what today's date is, you should automatically say destroyed, unless it was a matter under investigation or
Mhm.
still in the process of liquidation. That document's supposed to be gone,
Right.
finished. So that's one of the issues that we have. I find in terms of record retentions and record destruction.
Yeah.
Yeah. So like you were saying, there's nothing wrong with, like, say, if I'm drafting something on my computer that belongs to the company, the documents will be destroyed out of finalized versions that are actually put on the client's files.
Right. Yeah. Okay. I was just curious, really, because this person came from a larger, very large company,
Mhm.
and they were distraught that we didn't agree with that, to implement that policy.
Oh, no. Stick to the law and you'll be safe.
I know, right?
Yeah.
Anyway, okay.
Okay. Nobody else have any questions, comments?
Yeah, just a comment. I didn't realize there's a fine for keeping it beyond the time. That's wow. I didn't realize that you can be fined if you keep it, I guess, beyond the statutory period.
Mm-hmm.
Wow.
And you
learning
you
that.
can
Okay.
also have whoever the person is seeking can also bring action.
Sorry.
That's just someone is under investigation. And a request is made and say, do you have any documents here for Carolyn Roll? And you turn around and you say yes. And the relationship ended almost 12 years ago.
Okay. Okay.
Why do you still have it?
Yeah. Didn't realize that. Okay. So,
But you-
mhm,
They
go
like,
on.
oh,
Mhm. Okay. Know that.
what you got to say? You had a comment.
Right. So Denise had mentioned about keeping the electronic copy, or you mean just a document that was created?
Yeah,
So-
she made
Mhm.
draft. Like, let's say you were
Oh,
working.
okay.
That
Okay.
belongs to the company. That's not a part of the client's file. The client's file will be the finalized version of those documents.
I see. Okay. That
Yeah.
those should be gotten rid of too, any electronic copies you have. Those
Yes.
physical and okay. Understood.
Now you do have some FCSPs that scan all documents on their server. Like they'll have a
Yes,
list.
I would assume they should be deleted.
Those have to be.
Okay.
Yeah.
Okay. Okay. Thank you. Thank you.
Mhm. Yeah, because once you're gone, it's statutory period, it's gone. If you walk in the door today, you're a brand new client. Start all over again. I mean, there wouldn't be any place for all of this paper if you're to keep it, or
Yep.
enough space on a hard drive.
Right. Okay.
Ms. Archer, good afternoon. Sorry, good day. I have a question. What is the destruction period? The retention period is 7 years. What is the
7.
destruction period?
7 years.
Oh, both the 7, okay. Thank you.
Like I say, some companies, because of for comfort, some people are kind of scary. They say 10, but I'm saying, and that 3 year can cost you, expose the company to liability. So normally you try to appoint someone who is responsible for record retention, and along with that goes destruction.
Okay,
Yeah, because the whole part of archiving and record retention and destruction means that you have to have a policy in place that gives the time period for each type of document that you have. Not all documents remain for 7 years. So the company has to sit down and say what type of documents are to be destroyed along the way, and then which ones rest until the 7-year period.
okay,
Yeah. So it's not a haphazard function. Someone has to be dedicated to records management, as they call it.
right, okay,
Okay. So it's important to keep the records. Again, the limited liability protection. Also, you have to make sure you meet your statutory, legal, and regulatory compliance requirements. And it also allows shareholders to be able to inspect corporate documents properly and adequately. You can document the shareholders and directors and officers and their due diligence information. And you can also represent current and accurate information on the company, its corporate and financial affairs, and the shareholding. So even though this isn't an exhaustive list, it just signifies the practical need to have effective record keeping and maintenance to meet your legal, regulatory, and compliance risk. And failing to adhere to the minimum legal requirements of corporate record keeping and maintenance. So only thing I've done here on the other pages is just speak about just the sections and what you're required to keep. So we would have done it earlier in Unit 2. So all this is saying what should be kept at the registered office, whether it's a CAC or an IBC. So now that we've already discussed about destruction and retention, I think we should spend some time looking at our cases. And I wanted us to start with, I'm not going by name now, I'm going by topic. Let's do Jet Set first. Oh my God, it's Denise. Sorry. Denise.
It's just me trying to unmute my thing again.
Unmute.
Sorry.
Yeah.
But you knew that. Okay. So the assignment I had was with respect to a judge's decision where he explained his ruling to appoint joint provisional liquidators on 2 related matters heard in the Supreme Court of the Bahamas concerning the control and future management of a company, Jet Test International Limited. Jet Test was a business that offered jet aviation services and had 3 corporate shareholders, Windward, Seabird, and Freebird, who were also the corporate directors. Both matters involved the 3 corporate shareholders. A little bit of background: the ultimate beneficial owners of Jet Test were the beneficial owners of the 3 corporate shareholders, which were 3 Americans who, I'm not sure how much I refer to it later, but they are, to make it simple, A, G, and R. The business relationship between the 3 UBOs had deteriorated over several years, and A and G blamed it on R's substance abuse. Previous to these cases being brought before the Supreme Court of the Bahamas, the beneficial owners of the 2 defendants in one of these cases, who are Seabird and Freebird, filed a complaint in Nevada against R, the beneficial owner of Windward, with numerous allegations, including breach of trust and intentional interference with contractual relations. Shortly thereafter, they petitioned for and ultimately obtained an order from the court in Nevada to one, appoint a receiver, who I had to learn was a person appointed by the court to manage the affairs of a company. And two, to enter into a preliminary injunction to prevent the Jet Test shareholders and directors from interfering with the receiver. And three, a temporary restraining order. In spite of these legal efforts to restore the proper operations of the business, R and A were unable to overcome the challenges posed by R's misconduct, which led them to, just over a month later, petition to the Supreme Court of the Bahamas for the winding up of Jet Test on the grounds that R, the BO of Wynwood, R's conduct had damaged the company's financial well-being and reputation, and he had taken over complete control of the company without authority from the company and without, as a minority shareholder, the voting share to do so, also to the exclusion of the majority, and therefore on the basis that it was just and equitable to do so. The petition also requested the court to appoint joint provisional liquidators, this being the first of the two cases heard here. In the second case, Wynwood, who R being the BO, he was the minority shareholder, commenced an action against Freebird and Seabird, seeking the appointment of a receiver again to, among other things, take control of and value the assets of Jet Test, have access to all company records, and produce a report of its findings. Wynwood's summons also included an order that, subject to the findings, that one, a share transfer of Jet Test take place, or two, the company be dissolved and all assets and or liabilities be appropriately distributed, and such order, declarations, or relief that the court deems just and equitable. Take note that Jet Test was not a party to this action. All parties agreed that there was an urgent need for the company's management to be placed in independent hands. The one-third interest wanted a receiver appointed again, whilst the two-third interest wanted the company to be wound up and a provisional liquidator appointed. The applicable sections of law regarding the appointment of a receiver are Section 21 of the Supreme Court Act, which relates to the appointment of a receiver where it appears to the court to be just and convenient to do so. The relevant section of the IBC Act refers to the provisions of the Companies Act, which provide for certain procedures to be followed in the appointment of a receiver. The judge found that the plaintiff, Wynwood, their originating summons faced severe procedural challenges, and notwithstanding those, he was not satisfied that it was just and convenient in the circumstances to appoint a receiver, since they had already tried this in Nevada to no avail. The judge also was not satisfied with Wynwood's expectations as to the result of the appointment of a receiver, as a receiver is usually appointed when a company is insolvent, and it appeared that Jet Test was definitely solvent. Also, the plaintiff's request in the originating summons for the receiver to value the company and prepare a report could result in a share transfer or the dissolution of the company, which the judge felt was crafted as a relief for the shareholder remedy of oppression/unfair prejudice, without any reference to any statutory power to enable the same, and without naming the company as a party. More importantly, he recognized that the end process would most likely result in the dissolution of Jet Test. In all circumstances, he was not satisfied that the appointment of a receiver was a just and convenient exercise of his discretion. He was satisfied that it was more appropriate to appoint a provisional liquidator pending the petition to wind up the company. The applicable sections of law which pertain to the winding up of a company are Section 186 of the Companies Winding Up Amendment Act, which states the 5 circumstances where a company can be wound up by the court, and the one relevant to these two cases being if the court is of the opinion that it is just and equitable. The judge was certain that in this case, where the business relationship had soured, that it was a classic case for the winding up under the just and equitable ground. Further, Section 199 provides that after the presentation of a winding up petition, And before the making of a winding up order, an application can be made to appoint a provisional liquidator under the following circumstances. One, there is prima, I don't know how you say that, facie case for making a winding up order. Two, if the appointment is necessary to prevent the dissipation or misuse of the company's assets, to prevent the oppression of minority shareholders, and to prevent mismanagement or misconduct on the part of the company's directors. The judge was satisfied that after hearing the applications in the two separate but related cases, the circumstances existed for the appointment of a provisional liquidator, and therefore appointed AT and MF as joint provisional liquidators. I did not have the wonderful assistance of summaries of other attorneys on this matter, but I did put a lot of thought into this, how this had applied to perhaps what we had gone over. I guess with respect to certain articles being in place to prevent abuse. I mean, I know it was with respect, I think, to to amending the articles so that certain shareholders don't benefit more than others. But it was, I guess, protecting the, not protecting, but recognizing that the 1/3 shareholder did not have the authority or power to exercise what he was trying to do, as well as previous to this being brought, he did not taking control of the company. He was not authorized to do so by the articles. And on another instance, I think it's a classic case where all of the control, that being the members and the directors, should not lie in the same individuals.
Yes, yes. That's the key thing when I read it, when I read the first paragraph, because I have it highlighted on my copy. And this is you see a lot here when persons come to incorporate a company, because even sometimes before the company is incorporated, you hear they change their mind. I take off Mary Sue. I'm taking off this person, because
Right.
it is always happens. 2 persons, 3 persons, 4 persons decide that they're going to come and do business here in the Bahamas. They're going to incorporate an IBC. Then each one of those individuals want to incorporate a company rather than having their names on the registers. And then they turn around. The company is the member, and then on the register of directors and officers is their name. And it seems to always end up in situations just like this.
Right. There's no checks and balances. I mean,
No.
in foundations, not to get off the topic too much, but the certain, like the foundation council cannot be the same as the foundation, or be affiliated in any way to any of the officers, or I think the foundation agent, if they are the only officer, so I mean, again, just back to checks and balances. And I think abuse of the structure,
And that's what happened. And that's what happens, because even though they were trying to keep R out, R was a minority shareholder.
Correct.
Right. So even though R was the one that they were accusing of doing everything wrong, in when you look at it from the company perspective, he was a minority shareholder. And so in the eyes of the court, it would look as if the 2 majority shareholders was making sure that the minority didn't get what he should be getting as a shareholder.
Right. But unfortunately, the minority shareholder didn't get good lawyers.
Oh, he didn't.
I mean,
Nope.
that was also glaringly obvious. So I did take note of that.
Yes. His attorneys were not, I don't know what word to use, as the ones that were for the other 2 gentlemen.
They just weren't vested. I mean, not making the company a party to the action or the order, whatever it was called,
Done. Yeah.
So anyway,
So that's why I said I will let y'all see a few of the cases to see how it applies. Because it
Yeah,
really,
it's pretty interesting.
yes. All right, who's doing the Golden Gates Assembly? That's Carolyn.
Okay, Ms. Archer. So again, I tried my best on this one.
That's fine.
The case was very lengthy, because it actually cited a lot of, I would say, rules and regulations as it related to the memo of arts, memo of articles for the company. So, I read through and I did a brief of the
Okay,
case.
that's your brief. If you miss out anything, I'll just jump in. Go ahead.
Okay, so the case, was, in the matter of the Companies Act and, the Golden Gates Assembly World Outreach Ministries. And between the plaintiffs, which consisted of several persons, and and defendants, which also consisted of several persons. The matter was heard in the Supreme Court, Commercial Division, before the Honorable Justice Ian R. Winder. So this case involved a dispute between the membership of Golden Gate Assembly World Outreach Ministries, which was also the name of the company, a company that was formed in that name. And it was regarding the appointment of the bishop of that church, Bishop Ross Davis, appointing his son as the new pastor of the church. In reference to the company, as I said, is the Golden Gates Assembly and World Outreach Ministry. The company was incorporated under the Companies Act on September 12, 2001 as a limited company, as a company limited by guarantee. The subscribers to the Memo of Arts and Articles of Association were Bishop Roston Davis, Paul Roll, Mary Nan, Cleo Cash, Althea Woods, Althea Davis, and Jeanette Whitefrom. So pay particular attention to Bishop Ross Davis because he was, one of the main persons that actually you'd be hearing a lot about him in this case. The company was guided by the following highlights of the articles, which stated that the administration of the association was to be vested in the executive committee, consisting of not less than 5 persons, but not more than 9 persons as well. The executive council was the final authority of the association, and that would be determined by the members of the annual business meeting. The executive council consisted of the subscribers to the memo of association. The executive committee was appointed to act for the executive council in all matters. And the executive officers of the executive committee comprised of a president, a VP, a treasurer, assistant treasurer, secretary, assistant secretary, and a council representative. The article stated that an AGM was to be held annually in April. Following the first AGM of the company, on May 2nd, 2018, the secretary wrote a letter to the Registrar General advising who the directors and officers of the company were. Pastor Ross Davis was appointed as the president of the company. Following on July 1st, 2020, an executive committee, and note that I said an executive committee, passed several resolutions which were signed by 3 committee members. Those resolutions were based on several proclamations, one of which was that Archbishop Ross Davis did not have the authority to appoint or install a new pastor, that being his son, Pastor Trent Davis, as the next senior pastor of Golden Gates Assembly. As a result, the committee passed a resolution advising that stating that Pastor Trent Davis not be appointed or installed as the next senior pastor of the church without an election by both the executive council and the active paying members of the church. Moving right along, um, following that letter on July and those resolutions, on July 21st, 2020, an action was commenced by the plaintiffs, headed by Pastor Ross Davis, identifying themselves as the executive committee. The originating summons sought relief from the court, declaring that such resolution is not a resolution of the executive committee and an injunction, and sought an injunction restraining the defendants, their agents, from acting upon such resolution and interfering with the business or operation of the company. And in brackets, that will be the church. And Bishop Davis's affidavit filed on July 20th in support of the originating summons, among several statements, was that the executive council appointed in 2018 remained unchanged, and that in his capacity as president and senior pastor, he had appointed several pastors in the past, and as such, on February 23rd, he announced that he would be appointing his son, Pastor Trent Davis, as the next senior pastor of the church. So once the action commenced in the Supreme Court, following several cross-examinations and hearing the evidence of all witnesses, the case was summed up on October 8, 2021. So that case took quite some time. And following those cross-examinations, the judge advised that he was satisfied that there had been no elections to office of the executive council or committee, although every year annual returns were filed with the registrar general reflecting the company's officers and directors. He was satisfied that the original members appointed in 2018 were the standing members of the executive council. And because the plaintiffs did not form the membership of the committee, they did not have the power to pass the resolution on July 21st, stating that the president, who was Ross Davis, could not appoint his son as the new pastor. So as a result, the judge ruled that the originating summons was to be dismissed. He also made it distinctly clear that the members of the company at its annual meeting must decide the makeup of its council, which would be empowered to elect the membership of the committee for the management of the company. So in summary, what really happened there was that even though the company held its AGM, each year and appointed its officers and directors, one of the functions that it did not do was appoint the executive council for the company, who in turn would appoint the executive committee who would act on behalf of the executive council. That did not take place. So as a result, neither committee was actually in place for the company. So the presiding officers of the company, directors and officers of the company, stood up until the time that the case was heard in court. So as a result, Pastor Trent Davis did have the authority to appoint his son as the new pastor.
Mm-hmm.
So that's my summary of the case.
Yep, and you note in paragraph 26, where the judge says the company was organized by virtue of its memo and arts and the constitution, but there's no evidence of any such document coming into existence. So the company is to be managed and administered by two bodies, the council and the committee.
Right.
And then he also said that inelegantly drafted, the articles suggest that these bodies should generally mirror directors and officers of company. So he spoke to the person who drafted the memo and arts, saying that it wasn't clear enough for them to understand that they needed both bodies,
right,
in order to run the church.
And those bodies were not actually, and they were to be appointed each year at the AGM, which didn't happen.
Yeah, it didn't happen.
So as such, there was no such executive council and no such executive committee. It was just the presiding officers that were appointed each year at the AGM, which would consist of the directors and officers who were managing the company.
But isn't it strange that when they got into the pickle, they surely could find attorneys, though?
They did.
Yes.
Mm-hmm.
Able
They
to
had
find,
some good attorneys too.
they had attorneys ready, but again, they probably just spoke about the dispute without looking at the constitutional documents.
Correct. Correct.
Because they should have been able to pick out that, okay, hold on. The memo on art says you have the executive council, the
Mhm.
executive, who are the members on these, when did the meetings take place? Let me see the minutes.
Right.
But that didn't happen.
That didn't happen. They file those annual returns every year, but actually, like I said, the minutes did not reflect that those committees were actually appointed.
No, they weren't. That's very good. Anyone else have any comments? Anyone else read it?
No, didn't read it, but just had a question, please.
Go ahead.
In terms of drafting the, I guess, constitutive documents, those corporate docs, that should really be a legal person doing that?
Yes.
The legal mind, yeah, okay, and not just so much copying, because I know sometimes maybe you can copy over, if you have one for another company, you just kind of copy it.
And that's why
And that should,
you have a conversation with the client to see
Yeah.
if that's the clauses are what they want.
yeah,
Because nothing is worse than when there is a dispute. And then when you say, well, we have to go by the memo on arts, and then they
Yeah.
say, but that's not what I wanted. It's
Yeah.
kind of like a little late. I mean, you can't do an amendment, but then you need both. And I've seen that before.
What
Yeah,
stood out for me was that in the articles, they actually stated when they wanted AGMs to be held, but I thought it was just once it's held annually. I didn't know that they would actually stipulate a particular month for it to be held.
But don't forget, this is a church. This is an
Mhm.
NGO. And so you'd notice that their memo on arts has a little bit more detail in it.
Mhm.
Because some of them actually tell you what the pastor can preach on.
Oh.
Oh yeah, that some of them are in real fine detail.
Mhm. Well, I mean, like for me, I mean, I think what seemed to be their problem was, I mean, for the pastor to actually be the president as well. I mean, I feel like that's so conflicting.
I'm about to say, before you use that word, I was about to tell you now, when you talk about conflict, Bahamians don't know what that means.
Because if he's going to be the pastor, then he should not be the president.
Exactly. Because that means he's making all the decisions himself.
Correct. And that is exactly what happened.
Yeah.
And maybe he wanted it set up that way because that's a family church. So if he steps down, he wants his son to actually, be appointed and to take over the church. And he had the power to do that.
Yep. So again, if we look at the one that Denise did and her own Jet said, it's the same thing. It's just too much of the same people having control and directing and managing and owning. No, it's too much.
Yes, it's too much.
Too much. It's not clear. All right, let's do roll. Who has roll? Where's my paper? Roll is on pre-incorporation. Who's doing roll? Where's my piece of paper? Oh, here. Annie. Annie is in here. Yes, Annie is here. Annie. If not, Annie, you ready to do what is one name? Kramen? Is she on? Kramen was a good one. Did anyone read that?
No, I read the one that was just presented. I started to read it.
Oh, okay. The one with the church.
Yeah. And I took note of that inelegantly drafted.
Yeah.
yeah. Wow. So in a case like that, Ms. Archer or Denise, so you take that document, just to say it was drafted by a legal mind. what, I mean, who's the onus on? I think that person, because the regular person, the lay person doesn't know all the legal jargon and what should be in these documents. So then who, I guess I don't know if the church body knew or the council knew that the document was not properly drafted.
No, they would not have known.
Yeah.
No.
But you better believe the lawyer who drafted it would have no
Yes.
liability
But then-
whatsoever.
Really?
Right.
Really?
But remember now, the church had lawyers on standby. They should have given them the documents when they saw that they had dispute and asked them to read it and see how they could address it.
Yes, as well as not ever having implemented, what was it, a constitution or whatever?
Mm-hmm.
And I know actually of another very, very large NPO, a multinational one where we assisted with registering it for an NPO, and they didn't have their constitution either,
Mm.
or whatever, you know, the thing that guides. I don't know if I'm referring to it properly. Constitution, that, you know, the document that guides the
Mhm.
council. So you wonder how these companies are being run, you know?
Same way you saw this one was being run. Whoever's in charge runs everything.
Oh, yeah. I mean, they
Problems.
just form the companies, like you say, to limit the shareholders and
Mhm.
also to gain the NPO status.
Yep, and that's about it. And
Yeah.
then they whatever they feel like doing.
Right.
That's what they do. All right. So where's Wilson?
I am right here.
Well, are you ready?
You didn't give me any.
I don't think she had any.
I heard you saying Annie, but I read it. My name was not on there.
I don't think she had any.
Annie? I have Roll Family. You don't see that?
A note of who is gonna do the cases.
Yeah.
Yeah, I didn't. 3 cases. I saw 3 cases to present, 3 persons to volunteer. I don't,
And
I
my
don't remember who.
I didn't get any. I read the email. I didn't see my name there.
Mhm.
No.
All the names in the
No,
email?
ma'am.
Oh, wow.
All the names were not on the email,
Oh,
but there were
I-
about five, I guess.
Right, because I know Ms. Actor said she'd send more. I know there are 3 volunteers, but let me check the email.
1, 2, 3, 4, 5, 6. So in my
Yeah.
email that I sent go out, I have Annie doing Roll Family, Carolyn doing Golden Gates Assembly, Denise Jet Set. Then I sent the case of Kramen. Bars doing Investor, February 25th, and Shanice is doing Zone America on March the 4th.
Really? What else is
Yeah.
it? Wait, let me, Annie, okay.
I definitely saw.
Oh, I didn't read this. Oh my, okay.
Anyhow, don't worry about
Okay.
it. Who wants to do Kramen? Or we could leave Kramen until the next class and we could do Roll Family.
Is
I
Annie
didn't read
on?
any of them.
You did not read?
No, I saw the email with the cases and I did not even read down. Oh, wow. sorry.
Oh,
Yeah, he really didn't. So,
I was too busy cramming so I could do my jet test.
sorry. I did not read down. Oh, no. Okay. All right, well, I will be ready for the 25th.
okay. So when we come back, Annie, you could do Kramen then. So Annie, I'll put you down for the 25th with Bar.
Miss Archer, who's Annie?
I had to say Annie, I mean Wilson.
Because you saying if you put Annie in the email, I will not know who you're talking about.
That's Wilson.
So which one would I
There
be
was
doing?
Annie on the call last week. I think that's where the confusion is.
Oh,
Yeah.
okay.
And who
Yeah.
was her first? It was her first class last.
Yeah, so I have her down here too, but I'll take her off. Yeah, so Wilson, you'll do Kramen next week. I mean, week after next, on the
See.
25th.
Yes,
Along-
ma'am. I was
along-
looking for it. I just noticed that the thing said Wilson next to Kramen. I think I opened that when I was to work and my eyes didn't see that. It was my
Oh.
fault.
That's all right. That's all right. So if we look at roll versus roll, this is a Privy Council case. And this was an appeal with a family dispute to do with 2 plots of land in Bimini. The facts are on May 24, 2006, Emmanuel Roll conveyed 3 plots of land in Bimini to his daughter Ina by a deed of gift. Some 3.5 months later, in September, same year, he executed 2 conveyances, purporting to convey 2 of those plots to a company called Roll Family and Co. Limited for $100 each. The company is controlled by his son, Paul, who is the majority shareholder, its president and director. So of course, you know, under the Registration of Records Act, successive conveyances of the same land take priority in order that they are lodged and accepted. So on the 27th of May, stamp duty was paid on the conveyances, and on the following day, they were lodged and accepted for registration in the registry. Ina stamped and lodged the deed of gift in her own favor 8 weeks later, on the 18th of July, 2007. It follows that if the conveyances in favor of the company were valid, it has title in priority to Ina. You agree, right?
No, say that again.
Okay, listen to the dates. The 24th of May, 2006, Mr. Roll conveyed 3 plots of land to his daughter Ina as a
Right.
gift. 3.5 months later, he executed 2 conveyances, and he conveyed 2 of those plots to a company called Roll Family and Co. And that company is controlled by his son, Paul. Paul is the majority shareholder. He's also the president and director of that company. So on the 22nd of May, 2007, so that's October, November, December, January, March, April, May, 8 months later, stamp duty was paid on the conveyances in favor of the company. And on the following day, they were lodged and accepted for registration in the registry. Now, the daughter, remember now, the first thing he did was he conveyed the 3 plots of land to his daughter by gift.
Right.
So she stamped and lodged the deed of gift in her own favor 8 weeks after the brother. So she did hers on the 18th of July, 2007. He did his own on the 22nd of May, 2007.
And you said the registration of whatever act states that what?
It says that the conveyances in favor of the company, if the conveyances of the favor of the company were valid, then that means that it has title in priority to Ina, because the son had his property stamped and recorded before her.
I see. Okay. Okay. That's what I misunderstood. I thought you said
Right.
that. Okay. All right. Good.
So the problem arises from the fact that although on that date, lawyers had been instructed to incorporate the guarantee company, the formalities were not completed, and the company did not come into existence until the 12th of September, 2006.
Hmm.
4 days later. It
Hmm.
follows that at the time when the conveyances were executed, there was no grantee in existence in whose favor the deed could be delivered. The general rule of common law is that a company cannot adopt or ratify a transaction purporting to have been made on its behalf before its incorporation. In the ordinary course, the result would be that the conveyances in the company's favor were void. So the company seeks to avoid this result in 2 ways. First, it submits that the conveyances of the 8th of September, 2006 were delivered as escrows, conditional on the incorporation of the company and taking effect as valid grants when that condition was satisfied. Secondly, the company relies on Section 22 of the Companies Act, which validates pre-incorporation contracts on certain conditions. Both points have had a somewhat checkered procedural history. The company relied exclusively on the second point before the trial judge, who rejected it. Don't forget that the trial judge would have been here in Nassau. In the Court of Appeals, it conceded the second point and relied exclusively on the first, which had been neither pleaded nor argued at trial. The court was not persuaded and dismissed the appeal. So in the result, the company has so far failed on both of its arguments. So the court went through the whole topic of escrow. So let's go to section 22 of the Companies Act. It says, it is as the board conceives, because of the conceptual impossibility of assuming an obligation conditional upon the obligee coming into existence, that pre-incorporation contracts are commonly dealt with by a specific statutory provision. Section 22 of the Company Act is the relevant enactment in the Bahamas, and it provides so far as relevant. It says, except as provided in this section, a person who enters into a written contract in the name of or on behalf of a company before it is incorporated is personally bound by the contract and is entitled to the benefits of the contract. Within a reasonable time after the company is incorporated, it may, by any action or conduct signifying its intention to be bound thereby, adopt a written contract entered into in its name or on its behalf before it was incorporated. 3, when a company adopts a contract under subsection 2, A, the company is bound by the contract and is entitled to the benefits thereof, as if the company had been in existence at the date of the contract and being a party to it. And B, a person who purported to act in the name of the company or on its behalf ceases, except as provided in subsection 4, to be bound by or entitled to the benefits of the contract. So the Privy Council said the effect of these provisions is that an instrument which purports to be an agreement but is void because there is no counterparty in existence is nonetheless deemed to be an agreement for the purpose of binding, 1, the person who purported to make it on behalf of the company, 2, the company itself, if it adopts the transaction in accordance with subsection 2 in place of that person. So he says, let's go to the first condition. He said the first condition, which calls for attention on this appeal, is that the instrument should purport to be a written contract. It is unnecessary to decide whether any deed is to be regarded as a contract for the purpose of the section. The board is satisfied that the deeds in question on this appeal purported to be written contracts. In the case of Lot 85, there can be no real doubt about this. It provides for the company to assume an executory obligation to observe and perform an exception and reservation in the crown grant from which the grantor's title is derived. And the instrument is signed by Paul Roll, apparently on behalf of the company. The conveyance of lot number 20 is not executed on behalf of the company, presumably because the company's only obligation under that transaction was the payment of the consideration of $100, which is acknowledged to have been paid. But an agreement may be in writing, notwithstanding the absence of a signature. The conveyance of lot number 20 recites a prior unwritten agreement between the grantor and the grantee for the sale of the land in consideration of $100. It then subsumes the terms of that agreement into the deed. It also acknowledges receipt of the $100 from the company and thus the satisfaction of the company's obligation. In the board's opinion, the transaction effected by the deed was a bilateral transaction involving mutual obligations. In other words, it was a contract. Now, the next condition is that the company should have adopted the contract after its incorporation by some action or conduct signifying its intention to be bound thereby. He said it was submitted that this formulation means that there must be some executory obligation by which the company would be bound upon adopting the transaction. In the case of Lot 85, there is such an obligation, but the board would reject the submission in principle as regards both instruments because the suggested limitation on the right to adopt a pre-incorporation contract would serve no purpose that can be related to the object of Section 22 or sensibly be attributed to the legislature. It is entirely unclear why, for example, if the sole obligation of the company is to pay the price, it should be entitled to adopt a transaction where the price remained to be paid, but not where it had already been paid. In the board's opinion, the words quoted are simply intended to ensure that the company consents to being party to the transaction so as to assume whatever burden there may be and not just the benefit. It does not imply anything about the incidence or extent of that burden. In the present case, the payment of stamp duty and the lodging of the conveyance at the registry in the company's name unequivocally signified its assent to be bound by the deed. The main difficulty, as the trial judge proceeds, lies in the third condition, that the transaction should be adopted within a reasonable time after the company is incorporated. What is a reasonable time? In the case of Section 22, it means a reasonable time for the company to decide whether to adopt the transaction and to take the necessary steps to do so. There are practical reasons why the delay should be as short as is consistent with that object. The temporal limitation is not there for the benefit of the company. It is there for the benefit of third parties dealing with it. The decision whether to adopt a pre-incorporation contract affects the company's assets and liabilities, and thus the transactions which it is in a position to enter into with third parties. It affects the person who purported to enter into the transaction before the company's incorporation, who needs to know whether he is to remain personally liable and entitled under the contract or to have his rights and liabilities transferred to the company. It is no part of the purpose of the temporal limitation to allow time for the company to appreciate that there is a problem. If it were, there would be no effective limit of the time that might pass before the adoption of the transaction. The board accepts that there is room for argument about how long was reasonably required, but it considers that the 8.5 months that elapsed between the execution of the conveyances and the stamping and lodging of the deed for registration was well beyond the limit of reasonableness. The trial judge dismissed the action on that ground. The board considers that he was entitled to do so. So what's the consequences? It follows that the company does not have title to the 2 plots purportedly conveyed in September 2006. You agree?
I'm caught on the fact that I don't understand how Paul Rowe gifted them to his daughter Ina and then turned around and conveyed them to the Rowe family company.
He just changed his mind.
But how can you change your mind if you give something? I mean, surely there's some legal consequences of that. To that, I mean, aren't they now hers, and she is the one who could convey them?
Remember,
Correct,
now,
I agree.
it's just as if I had, okay, let's say I had 3 plots of land and I conveyed it to you, right?
Right.
That same night, I decide, oh shoot, I give her 3. And she was even listening to what I was saying. And she's arguing with me. And then Carolyn comes and Carolyn say, well, how come you give Denise the 3 plots of land? I thought you were giving me 2. I told you what I had to do. Okay, I'll give you 2. Same land, you know.
Yeah, that's
Remember
what I'm saying. But I thought once you conveyed it, it's no longer yours to convey
Oh,
again.
that he can do that. The whole issue is who records it first.
Mm.
See, the dispute between father and daughter and son. Daddy, how you could do this? But in law is who is the first. Now, he did it first. The son.
And the company he recorded it in, the name, whose name he recorded it in, is that the one that had not yet been incorporated?
Yes.
Okay.
And he didn't do it until 8.5 months later.
I thought he did it in May.
He did it in May 2007.
Oh, right. Okay.
Yeah.
And then Ina did it 8 weeks after, I thought you said.
After him, yes.
So his, but his was first, but not, the company was incorporated.
You got it.
Oh.
And because he took too long, it was not considered a reasonable amount of time
Yes, yes.
to then, okay.
All right, so let's go. The judge isn't finished yet. So the judge says, this leaves unresolved the question, who does have title? It will not necessarily be Ina, because it is arguable that since the transaction is void at common law and the company cannot claim title by adoption under section 22 subsection 2, the legal owner is Paul by virtue of section 22(1). Remember now, he can't get it under 22(2) because the company was not incorporated. But he could get it under 22(1) as a promoter. Another possibility is that Ina might derive rights from the fact that the failure of the company's claim leaves her as the only claimant on whose behalf any conveyance has been lodged for registration with the Registrar of Records. The board is unwilling to express a view on these points because Paul Roll is not party to these proceedings, and the implications of the board's conclusions have not been fully addressed in the arguments on this appeal. They would need to be properly considered as between Paul and Ina in proceedings to which both of them were parties. So the only question under this head, which the board thinks is right to address, arises out of a submission made on behalf of the company to the effect that if Paul Roll has the legal title to the two plots by virtue of section 22(1), he would hold it on trust for the company. The board cannot accept this because it is not consistent with the statutory scheme. Remember, subsection 22(1) means that he is acting in his personal capacity. So he can't hold it on trust for a company that was not in existence at the time that it was recorded. So the scheme makes the company's interest in the transaction dependent on its adoption of the transaction within a reasonable time. Equity cannot intervene to create a trust that is inconsistent with the statutory principle.
So he owns the two plots, Paul the son, just on his behalf. So can it be finalized that he owns the two plots just on his own behalf?
No,
So
they have to go to court.
Sorry?
They have to go to court in
Oh,
their
yeah.
personal capacity.
So it isn't resolved, the matter, or they'll have to go to court. Oh, I see. Okay.
Because the board said they would need to be properly considered as between Paul and Ina Roll in proceedings to which both of them were
Right.
party.
Right.
one-
both.
one.
Okay. Okay. So the
So-
point, sorry, Ms. Ashley, the point how he could convey the property that wasn't incorporated, who checks even at that point? I just trying to, so you just convey a property, but it's not incorporated, like the
Well,
name
there's
you're
no-
putting it in?
There's no mention of an attorney. Because I mean, if an attorney drafted those documents, the first thing they should have confirmed was that the company was in existence.
Okay. This is all.
Yeah. So I mean, there could have been an attorney in this whole process who just probably didn't check. He probably said, I have a company I could use, XYZ company. And they just went ahead and inserted in.
Name.
Front.
Oh. Okay,
Yeah, but checking.
interesting.
Mhm.
Mm.
But you see how section 22 is applied, right?
22, 1 or 2?
22 1.
1.
22 2 was in this case. But I'm saying when we were reading it, I think it was Denise who was saying she hadn't come across that section in terms of dealing with companies, but it can happen in different ways. The person doesn't have to go out to say, I am a promoter. Because it would fall under section 22 1, because he's taking personal liability, the company is not incorporated,
Right?
then he is a promoter in terms of
Okay.
company.
So you could just be deemed a promoter. You don't have to formally accept that role.
Exactly.
Hmm. So is that where a liability can come in, I guess?
Yes. Yes.
Even if it wasn't his intention to be a promoter, because he thought that he was conveying land to an established or incorporated company?
Yes. By law, it falls under section 22 1.
Hmm.
Yeah. So he becomes personally liable. So now they have to go to court and decide who actually owns the property.
Don't put that on the midterm here.
Wow.
You know, I'm thinking, right?
No, don't bother with that. Leave that make some more people right there.
So there's no class on Saturday because that's your midterm. So if I send you the exam tomorrow, would that be okay?
So it's not in person?
No.
Well, I just
Paper.
confirm them.
I thought we was getting that exam today. I was waiting.
Oh, you was waiting to do it today.
No, I was waiting to get it today. I was trying to get my kids have their exam this week. I was trying to push myself out of the way first.
Oh, you think you could finish your exam in 2, 3 hours?
No, not 2, 3 hours. I could spend the whole day and some of Monday.
Oh, okay. All right. So let me see what I could do and put it together for you.
Take home.
He didn't answer.
Oh,
Well, it had to be take home now because that's how I'm
Yes.
going to write it.
great.
Yeah.
The
That's
decision is
great.
ours.
Great.
That's how I'm writing it. So that's what it will
Great.
be.
Yeah.
Ms. Archer, this is due next Saturday, by a specific time?
No,
be
we're
Or
going to
12
She said
a.m.
12
midnight,
a.m. 12
right?
a.m. Yes.
Yeah.
Yes.
Okay, midnight, Saturday night.
Yes.
Yeah, that's fine.
Okay, good stuff. Okay.
You have Saturday. You can still make your runs, and if you peck on it every night, you'll see.
Mhm.
It won't be more than 5 or 6 questions, and not all of them will be long.
Great.
Okay.
Yeah, you're just advising someone what to do.
And just make sure the concepts are simple, not all that equity and trust and all that sort of stuff.
No, they're simple.
Yeah.
It'll be simple. You just
So
have to
you-
read sure.
Mhm.
And let them not be Bahamian cases so that we can cheat and use
Oh,
summaries by
gosh.
other lawyers.
The Bahamian cases are the best part.
Yeah, they're interested. Wow.
They might be interesting, but not if you have to dissect it and
Convoluted.
yeah.
Mhm.
Okay. But this time I won't give you any. For the finals, I will.
Oh,
No, but I'll tell you which cases they are if I decide to.
okay.
On the last day of class, when I say let's just quickly go over the areas for the exam. If I wrote a question that refers to a particular case, I will tell you what that case is.
That's skills that you develop though. You got to develop skills to be able to read these cases and extrapolate the application.
Yeah, but it
Seriously.
wouldn't be a case that we have not discussed in class.
Okay.
Yeah. It'll have to be something that we've already discussed.
Okay, good, because I find this very difficult. That's why I didn't become a lawyer. I'm serious.
Yeah, but
Legally, terrible. Mhm.
yeah, but you can see when you read things, a lot of things between the lines, like you say, inelegantly, the little words that drop here and there, you see a lot of cracks.
Sure.
Yeah, a lot of cracks. All right, so wait for my exam. Be ready to go.
All right.
Right, and
afraid.
if you finish early, you can still send it. All right.
You'll hear your email going off at 11:59.
Right, I know. Yep.
Procrastinator extraordinaire here. Okay.
All right. 11:59. I'll wait to hear all the blings.
Yep.
Yes.
All
All
right.
right. Thank you.
Enjoy the rest of the day.
Too.
You too.
Thank you.
Okay, good
You
day.
all.
Bye.
Bye.
Good day. Bye-bye.
Bye.